everyone, and welcome to today's Mondac webinar in association with Stevenson, Wong & Co, who will be exploring personal data privacy and cybersecurity in the context of employment handbooks in Hong Kong. My name is Dan Sampaio, and I'm joined by a brilliant panel to take us through today's discussion. Millie Hung is a partner in the Employment, Litigation, Disputes Resolution and Arbitration Department of Messrs Stevenson, Wong & Co. She has over 20 years of experience to advise on litigious matters, both in civil and criminal cases to the local government, foreign and PRC corporate entities, or individuals specialised in the practices of employment, aviation and transport, insurance and personal injuries. Michael Lau is a senior associate of Stevenson, Wong & Co, and his main practice focuses on litigation, dispute resolution and employment laws. He regularly advises clients on contentious and non-contentious employment matters and has experience in representing clients to enforce non-competition, non-solicitation and confidentiality and obtaining injunctions. He has handled discrimination cases, harassment cases and complaints from the Equal Opportunities Commission. Before I hand over to the panel to begin today's webinar, a housekeeping item. You are able to submit questions to our panel by typing them into the questions pane of a toolbar on the right-hand side of your page. And we do encourage you to get those questions in. We'll have a Q&A session at the end of today's presentations in which we'll endeavour to answer all of your questions. It's now my pleasure to hand you over to Millie and Michael to begin. Thank you.
Good afternoon, everyone. Welcome to our webinar, Office Handbook under the Hong Kong Employment Laws. I'm Millie Hung, partner of the Stevenson Wong & Co, and the gentleman sitting next to me is Mr. Michael Lau, senior associate of our firm. We have some experience to deal with employment laws in Hong Kong, so that's why we want to share our experience with all of you. First of all, maybe we have understand what's the agendas for today's. Slide 2 will show some of the major agenda. First of all, we will discuss the legal status of the employment handbooks first, whether its nature, whether it is incorporation, can be incorporated by express terms or some non-existence at the time of the contract, what happened. And then we will give you some taste of the common components of the employment handbooks. At the same time, to cover the major portions of the employment handbooks, do you have any contraries to the personal data privacy ordinance or some cybersecurity tools, or even though the discrimination ordinance? We want to use the remaining 1.5 hours to just share our experience with all of you. Slide 4, we can see actually, the legal status of the employment handbooks is just not legally binding. It is very clear. It's just a guidebook. If you want to incorporate some terms in the employment handbooks in the employment contract, it is possible because you can, by express implied terms, to enter between the parties to just make it form part of the contract. But if the terms being relied on does not form of the employment contract, you also have to use very clear words, excluded. Otherwise, there will be some messy situations that why the employment dispute will come up is just because of that. So before you, maybe we can share a little bit experience in this aspect, because some of our clients just pay so much attention on the employment contract, but not the handbooks. But actually, handbooks covers a lot of the areas that for the company itself, or even to regulate the relationship between the employer and employee is quite important. So that's why we just want to run through all these important terms to see whether we can assist you in the future. Slide 5, we can see some terms incorporated by mutual agreements. That definitely you can incorporate some office handbook terms into the employment contract. If there's mutual agreement, so long as it does not contravene to any rule of law or enactment or ordinance. But sometimes you will just get some hit up because by common law, or maybe you're not very familiarized, or some enactment which is may not be you are free liberty to enter into the free contract. We take the restraint of trade clause as example. Prima facie, it is not enforceable if even you express it to be part of the employment terms. But if you meet with some requirement laid down in some case law, it is okay. What is the requirement? It should be reasonable in the interest of the parties and also in the public interest. At the same time, if the employer can prove they have some legitimate business interest requiring protections, it is also possible. But no matter how wide the scope will be, you have to face that it should not be wider than reasonably necessary. What does it mean by reasonably necessary? In the case of the Buchanan and Janesfield in 1981, just very clear cut, if three main factors you have to consider whether it is reasonable, necessary. First of all, it is whether it is reasonable in point of time. Secondly, it is reasonable as to the geographic area of its operations. Thirdly, it is whether it is reasonable as to the restraint it imposes on the employee, irrespective of the type of work in which he is not permitted to engage. Take an example, just like a waitress. When you just apply restraint trade clauses on a waitress, you cannot just say you should 6 months, 1 year not to commit yourself in any catering business globally. It's definitely unreasonable. But if you impose a restraint trade clause for just like 6 months, 3 months on directors, that sort of thing, with the limited geographical limitations, and also specify the type of works that they should not be joined. It is most of the cases in Hong Kong is held. It is enforceable. So we can next slide, please. Incorporations can by many methods. One of the way you can incorporate the Employment Handbook's terms into employment contracts by reference. You don't need, because as we have already discussed, Employment Handbook is some sort of regulations or just guidelines or policies. You don't need to recite every word in the employment contracts telling that which terms are the terms that you want to be part of the employment contract. But but the wordings you use should be precise and not confusing, because as one of the cases, say the Kwan Carmen case, we can see that even if the terms are expressly incorporated, it's still necessary to consider in conjunction with the words of incorporations whether any particular part of that document is actually a term of the contract. Otherwise, the court will look into the common intention of both parties to determine whether the terms should be ruled as part of the employment contract. So next slide, slide 7, we can see if we were talking about the incorporation by reference, is it possible to refer some handbook terms which is already long time ago or never or at the time of you enter the employment contract, it's not yet existed. So some of the cases will tell you it is not possible. Handbook, if only just came into existence 2 years after the employment contract, the employment letter did not refer to the handbook, and it's very clear, using a clear wording that it was not intended to serve any contractual purpose. The court will rule that, sorry, it is not part of the contract. You can rely on the handbook terms to negotiate with your employee. So similar rationales in the Susanna International Company Limited and Chong Chern case. If there's outdated employee handbook that has not been referred to in the employment contract, the employer so still cannot rely on all these terms to argue with the employee. So next slide will show some if there's some contractual terms already agreed between the parties to incorporate from the handbook. How about the handbook terms change from time to time? And in this case, the Chong Chen Lin and Cathay Pacific Airways Limited has clearly stated that if it is the common intentions of parties, and if there's any change of the handbook's terms, the court will still rule that if the terms, the amendment terms is comply with all the contractual elements, which is offer acceptance, considerations, and intention to be legally bound, the court will still hold that it is possible and enforceable for the amended terms in the handbook to incorporate into the employment contract. In this case, in this Chong case, we will see that actually there's some factual background. Just give to you, you have some idea. It's just called a case for change of the some retirement travel benefit provisions. The court held that because it is a major and it's very important employment terms for the employee, and there are also some clear words in the contract and the handbook to refer that part of the handbook should be the part of the employment contract. So the court upheld all these contractual terms, but the court will think it is a case of variations but not incorporation, because the handbook was pre-existed. It's already there's first versions of the handbook in hand. If there's a second versions, the court will consider it whether there's valid variations of the employment terms. So consideration is quite important in this scenario, because if you cannot convince the court that there's sufficient adequate considerations, it's possible the court will rule out that particular terms to be enforceable and employment contract terms. So next slide, we will see the incorporations. We can incorporate the office handbook terms into employment contracts by reference, by whatever. But at the same time, we can incorporate some terms from the employment handbook by implied terms. What scenario will happen if the court will do so? Because it is by operation of law where no term has been expressly agreed, or where express term is unenforceable, or even by common law, we can see some implied duties, just like the fidelities to all the employees will be implied into the contractual terms. If it's not clear, the court will help you to clarify it. But all these implied terms, they have some criteria to meet. In the next slide, slide 10, we will show you a case for BP Refinery Property Limited and President and Control of the ratepayers. In that case, the court has clearly laid down some criteria that you have to meet for implied terms. It should be reasonable and equitable, and also it's necessary to give the business advocacy, and also it is obvious and capable of clear expression and does not contradict to any express term of contract. If the contents of the terms of the implied have been met all the criteria, whether it can match, it just depends on the factual matrix of the case, where at the time of the making the contract, both parties have already met with all these criteria. But how about if the handbook is not existed at the time of when the contract is concluded? What happened? You will see if the document did not exist at the time when both parties entered into the contract, the court cannot help anymore, because you can even both parties subsequently undertakes okay, part of the handbook's terms can be binding, can be ruled as the binding contract between the parties. No, the court will not say so. The court will just say it means that the employer, even they undertake, even both parties agree, if at the time or when you enter the employment contract, the employment handbook is not existent, you cannot do so. And also there are some restrictions when we incorporate the employment handbook's terms into the employment contract. Of course, the employer and employee are free to negotiate, agree on the terms or the conditions of employment, but they have to some proviso to met under the current law or common law, especially in the Employment Ordinance Section 70. Any terms of the employment contract that purports to extinguish or reduce any rights, benefit, or protections conferred upon the employee by the ordinance will be void. So no matter you will just draft a very detailed or perfect terms to agree between the parties, but if it is you try to try to affect the rights of the employee, the benefits under the statutes, under the ordinance, under the common law, the court will not help for these terms. So it is the very general ideas about what is the legal status of the office handbook. But I can give you also some general ideas about the common components in the employment handbooks. For the next slide, 14, you will see usually the parties, employer will use the handbook to introduce some company backgrounds or attendance policies, especially the company's cultures, to try to give some general idea about the employee, what kind of the company they have already engaged. But at the same time, as an employer, you can use this opportunity to clarify the workplace environment. And next slide, you will see for the workplace environment, it is quite wide. You can explain the confidentiality or there's some data protection rules here. And also you can illustrate how the employees are expected to do in different scenarios when, for example, there's a data breach or there's a cybersecurity crisis. What can they do? Report to whom? What sort of the procedures they should do? And some of the handbook, you also will see the code of conduct, which the employer wants the employees to comply with. Especially when you want to establish some clear security and data protection guidelines regarding the employees' conduct when they're handling the client's information, or how to use the company's computer, or how to transfer the data between the mobile phone and the company's computer. All these sorts of things you can reconsider to put here. And also about the employees' compensations, benefit and protections. It touches on how to provide trainings to employee on using safety protection software, or explain to the employee's own personal data also can be protected. You can also discuss in the handbook and just give a guidelines for the employee to comply with. So I just want to give this a very general guidelines or some ideas for you. But later, for the deeper discussions, we will try to concentrate on some particular area, especially the personal data privacy ordinance and the cybersecurity, even the discrimination ordinance. So I can next part is the personal data. I will pass to Michael.
Oh, Michael, I don't think we're able to hear you at the moment. I believe you're on mute.
Hello. Sorry, guess we just had some technical problem. Now I think the mic is fixed. All right, let me start over. This part, we are going to share with you our some ideas about the Personal Data Privacy Ordinance and how that relates to the Employment Handbook. In the previous section, Millie had mentioned the components of an Employment Handbook, and the components include the Code of Conduct and protection to the employee. And when it comes to personal data, the Employment Handbook can help you meet the Personal Data Privacy Ordinance requirements. From now on, I will simply refer to the ordinance as PDPO. So on this slide, you can see that there are 6 data protection principles. And this PDPO is a principle-based legislation applicable to both private and public sectors. The 6 data principles are the purpose and manner of collection, accuracy and duration of retention, use of data, data security, openness and transparency, and access and correction of personal data. Normally, or maybe perhaps I should say more often than not, we will see data principle 1, 3, 4, and 6 dealt with in Employment Handbooks. Moving on, we are going to talk to you more about principle 1. Principle 1 is on purpose and manner of collection. The first principle requires the employees to be guided to collect personal data that is for a lawful purpose and related to employers' business functions and activities. There is a case, Ri Chang Hui Mei Q. In that case, the court outlined that it must be against a statutory provision and not merely contravening company policy to be considered unlawful. An example of an unlawful purpose is how one should not use a job vacancy to solicit the submission of personal data by job applicants for the purpose of unlawful discrimination against those people, those job applicants. In that scenario, the collection of data could be contrary to the Sex Discrimination Ordinance. Next, we have to look at the purpose of the data collection. The data collection must also be necessary and directly related to the purpose as mentioned, and the data collection must not be excessive but justifiably adequate. On the manner of collection, which we will see on the next slide, employees ought to be guided that any personal or third-party data should be collected by fair and lawful means. The definition of fair and lawful is circumstantial, but however, this description can perhaps be well framed by the illustration of unfairness, whereby collecting clients' personal data while they are unaware when socially chatting with our clients implied or expressed consent would constitute unfairness. It is essential that personal data or third-party data must only be collected after taking all reasonable steps to explicitly or implicitly inform the individual. In other words, we must ensure the employees do know the requirement, and when they collect the personal data, meet the fairness, the necessity, and the directly related purpose as mentioned. And this guidelines may be put in an employment handbook. Moving on. Before the collection of personal data, the employees must be informed of the guideline. So it is common to put in an employment handbook regarding their personal data, the purpose for which the data is to be used, and the classes of persons to which the data will be transferred. And this must be, the employees must be told that this information or these notices must be given to the data subject. The purpose can be stated in a general or specific terms, and in any employment context, an employer may state the purposes for which employment-related personal data is to be used in the general or specific terms. Common purposes include to pay the employees, to contact the employees when the employee is absent from the office, to make tax returns, to assess the employees' training and development needs, and to administer a retirement or provident fund scheme to which employees contribute and from which they may benefit. Moving on, similarly, when employers handle the employees' data, employees also hold the right to explicitly know the purpose of data collected and classes of persons that their data will be transferred to according to the PDPO. So in other words, the employees may be informed by the employer by a provision in the Employment Handbook on how their personal data will be dealt with. But there are exceptions as shown in the next slide. In the Chen-Hu-Mei-Kyu case, it was ruled that notice was not required if the employers were to collect hard evidence on the applicant sleeping on duty for the purpose of the hospital's employment of the applicant and monitoring her performance. Well, as in the case, prior warning was not needed if the purpose was to monitor and collect evidence of employees' work performance regarding the employee's employment of the staff. Whereby personal data is considered by one or more persons for the purpose of determining one's promotion or removal, it also falls within the exception to the principle. And well, we've taken two related principles and put them on the slide. You can see that in the Chen-Hu-Mei case, it is related to the promotion in the employee and or removal from the employment or office. So you may be aware that we did not mention the word consent. And looking at this slide, you will see that the requirement is to, the obligation is to put on the employee to provide personal data to the employer. But however, the employees do not hold complete freedom to choose whether they wish to supply the information to the employers. In some cases, they are mandated to supply information as requested. We are going to look at the circumstances in a case, Cathay Pacific Airway, on the next slide. Yes, on this slide. In that case, it was held in the appeal that in situations where adverse consequences might be brought upon non-disclosure, for example, health consequences, it would not be fair if supply of personal data was made compulsory. It would not be unfair. In these cases, disclosure of data is properly compulsory. Subsequent threats or undue influence by employers would be inevitable to inform them of the consequence of non-compliance. Though the manner of threat may be brisk and blunt, this does not make a request unfair or improper. Simply put, if there is a good reason for the threat or undue influence, then it may be possible to compel the employee to provide personal data. So how does that relate to an employment handbook? If there is any reason for you to compel your employee to provide their personal data. For good reason, for example, health consequences we just mentioned, it may be wise to put it in the Employment Handbook. For example, you can put a term saying that, well, I'm going to need the employee to provide certain type of personal data for a specific purpose. And you may even state the consequence of not providing or not complying with this particular term of an Employment Handbook. But at the same time, you must put in a good reason and explain to the employee why this is necessary. And in the eyes of the law, this would not be seen as a unfair term and may be seen as properly compulsory. And we mentioned a case of collecting of personal data without the consent before. The collector had evidence, if you remember, just a moment ago. And moving on, we are going to look into more exemptions and issues of collecting personal data by CCTV. Looking at the data principle, protection principle 3, personal data is exempted where the data is used for the purposes of prevention, preclusion, or remedying of unlawful or seriously improper conduct or dishonesty or malpractice, whether or not the data are held for any of those purposes. There is a case, John Paul Mann case. Footages of a CCTV was held should not be used for a new purpose. Definition of a new purpose is any other purpose apart from the originally intended purpose of installing the CCTV. And in this context of employment law, may possibly be monitoring the employee's business or any cases of shoplifting. Any new purpose must have the consent of the data subject. For example, if the CCTV recordings are to ensure the safe security of the shop, it may not be used to monitor the actions of the employee during lunch hour, because doing so would become a new purpose. So it is important to make sure that if you state a purpose for collection of personal data in the Employment Handbook, you must ensure that the personal data is used for that stated purpose instead of for other purpose, unless such new purpose is informed to the employees or that new purpose falls within the exceptions that I've just mentioned earlier on. Next, we are going to look at the use of data. Personal data must only be used, that is to say, disclosed or transferred with prescribed consent. Data user can only use the personal data for the purpose that is consented by the required data owner at the time of collection. Now, one thing to note is that a data user who fails to take reasonable practical steps to ensure the personal data is not used accidentally or without authority will be liable to compensate a data subject for any consequential loss. In addition, a complaint may be lodged with the Privacy Commissioner. On the next slide, there is an exemption to this data disclosure. Personal data is exempt from this data protection principle if the data is required by law or court order in Hong Kong, or required in connection with legal proceedings, or for defending legal rights in Hong Kong. But there are something that you should pay attention to when it comes to these exemptions. Moving on. You can see that these exemptions does not, however, create a legal basis or obligations for the data holder, that is the employer here, to disclose the information. This only occurs when public interest prevails over the interest of confidentiality. But in practice, it is very rare to see the other way around. In other words, it is quite rare to see that the public interest does not prevail over the interest of confidentiality if, for example, that the personal data is required to be disclosed in connection with legal proceedings. So in gist, one thing to note is while there are exemptions, the exemptions does not create an obligation. So there's a distinction that you must pay attention to. Next part, we're going to talk about the data security. People in Hong Kong are probably aware of a recent news article about Cyberport data breach incident, and that was reported to the Privacy Commission of Personal Data on the 18th of August, just last month. The data privacy principle 4 requires that all reasonable practical steps to be taken to ensure that personal data is protected from unauthorized or accidental access, processing, erasure, or other use. All reasonably practical steps must be taken to ensure that personal data held by data user is protected against unauthorized or accidental access, processing, erasure, or other use. The term use includes the disclosure or transfer of such data. So maybe in the employment handbook, it should be providing guidance to the employees on how to use the data. Employees should be guided on practice to determine the steps that should be adopted to protect personal data, such as the kind of data and the harm resulted, physical location where the data is stored, security measures incorporated, measures taken for ensuring the integrity, prudence, and competence of persons who have access to the data, and measures taken to ensure security transmissions of data. These guidelines should be provided in the Employment Handbook to provide a full security protection of personal data, no matter the personal data is employees' own or customers. And the fourth principle also detailed possible guidelines or possible guidelines to prevent data leakage and breach of this particular principle on data security. This can be observed in secrecy and confidentiality statements where the staff involved in accessing or processing personal data should be required to sign a secrecy or confidential statement. The consequences of breaching this may be an appropriate investigation procedure and action against staff violating the terms of this statement. So another way to do it is to put the statement in the Employment Handbook and give the employees a warning that if they do not follow the guideline, consequences are coming. More on the data security principle. Here we are going to see some example guidelines. Staff should refrain from carrying physical documents or digital storages out of office, and prior approval should be sought before doing so. If carrying out is unavoidable, personal data should be first redacted or removed, and only necessary documents could be taken away from the office. Another example can be that employees should also follow the shredding procedures of documents which are no longer required for use. So these are just examples, and of course may not apply to all businesses. But if your business actually deals with personal data, then and employees have a chance to work from home, and perhaps sometimes employees may bring USB drives back home, or sometimes physical copies, then you may consider including these guidelines in your employment handbook to give the employees an idea of how personal data must be dealt with. Next slide, we are moving on to the last data protection principle, that is the sixth, on the principle of access and correction. Employees are entitled to ask for correction of personal data concern if he or she considers that the data is inaccurate. This can be done by asking or telling the employees to submit a data correction request to the data user, that is the employer. Such a request may be made by a properly authorized relevant person, and you may state who that properly authorized relevant person is in your employment handbook. Employees are entitled to have their data corrected within 40 days of submitting their request, and if not, the employee is entitled to receive a notice in writing with an explanation of why the data could not be corrected within the 40-day period. So these guidelines are just for your information, but most importantly, you have to make known to the employees once they notice that their personal data is wrong or inaccurate, how they may deal with it and who they should contact so that their personal data may be corrected. And we mentioned that the employees may submit a personal data correction request, and you may consider putting in the employment handbook, telling the employee how to make such request. For example, you may state in the employment handbook that such request must provide sufficient information, file the request in Chinese or English, ensure that original data is genuinely inaccurate and correction provided is genuinely accurate, and reminding the employee to refrain from providing false or misleading information. So this is some guidelines that you may provide to the employee in the employment handbook. We have talked about the legal requirements. Now we look at the consequences on the next slide. The consequences of non-compliance to the data protection principles are not itself a criminal offense, but the Privacy Commissioner may serve an enforcement notice after investigation to direct the data user to remedy the contravention. Failure to comply with the enforcement notice would then be an offense. The penalties incurred for such an offense would be, well, at first conviction, a level 5 fine, that is 50,000 Hong Kong dollars, and could lead to imprisonment for 2 years. If the offense continues after conviction, a daily penalty of $1,000 will incur. For a second or subsequent conviction, a level 6 fine, that is $100,000, and imprisonment of 2 years may result. And if the offense continues after the conviction, there will be a daily penalty of 2,000 Hong Kong dollars incurred. So be aware, even though that may not be an offense, but if not reported or not following the Privacy Commissioner's enforcement notice, that could lead to very serious consequences. Moving on, we'll be talking about the cybersecurity aspect in employment handbooks. I will pass this back to Millie to talk to you about cybersecurity.
Before I start, I just want to just add a little bit of the materials on following Michael's discussions, because Michael's concentrate on the Hong Kong's personal data privacy ordinance. But actually, if you are some clients or some companies which touches on the EU residents' personal data, the GDPR is also another important enactment you have to pay attention. I think the punishment for non-compliances is much more serious than that of the local domestic law. So maybe because today's time is limited, so we cannot cover all these materials in one webinar. If it's possible, then we will discuss further whether we can provide one more additional webinar to talk about that. But yes, I just want to remind all our honorable audience to understand that the consequence is not just some fine to the companies, but also sometimes it is the personal liabilities for some directors who fail to comply with. Okay, then let's move on to the cybersecurity in Employment Handbook. Actually, the Employment Handbook, as we discussed previously, that is a kind of the guidelines to the employees. Just provide some. We want to provide some clear guidance to the employee, and also provide the best practices to how. Of course, cybersecurity is aimed to protect the company's assets or from the cyber threats. If a company wishes to make some information security policies binding, those policies should be incorporated in either the employment agreements or use a clear wordings to refer them in the employment contract. Yes, the slide shown in front of us is generally we will talk about today. For the anti-money laundering, AML, it is quite important or very hot topics nowadays because the amendment ordinance is just come into operations on the 1st of June 2023 this year. So some of the requirements I just wonder whether every corporate companies or directors we are aware, but we'll try to share some updated information with you. And then cybersecurity is important for the company because you have to secure the company's own assets. At the same time, how to do it? We can buy the companies some self-owned hardwares. You can, because the COVID, you see there is some remote works or some mobile device, which is so common to be adopted by the employee. So should you just recheck with your handbooks whether there's sufficient guidelines for them, how to use their personal mobile phone or laptop to do some very highly confidential projects of the company. So I think this part, most of the audience will have to reconsider. And about handling the company software, yes, for the IT software, so antivirus software, so you can leave it to the IT expert. But for the general guidelines, what happens if there's a cyber threat or there's suddenly there's just like the cyberport case, what suddenly happened, unfortunately, what should the company do, or what is the employee needs to know who to report? What's the next steps? I think in the office handbook should lay down some foundation for them to follow. So I've marked here is the cybersecurity policy and procedure you will be aware to mention, and also some anti-cyber attack software, what sort of software we should use, and regulating access to company's data. You will say, oh, I'm anti-money laundering. It is far away. It's not related to our company. But once because the AML ordinance came into force, it is far away in July 2011. But amendment sections just update on this June 2023. Some of the terms, amendment terms, is just to try to catch all the what we call is FI or DNFBP, financial institutions or some other specific organizations to verify the customer's identity and assess the risk of the potential money laundering or terrorist financing activities. So the company, when they try to know their client, try to know their client, try to know their client, they would have to store their client's data in the data bank. So it is sometimes you notice when there's leakage of the IT protections of the companies and the client's information is leaked out. What happened? It will go back to the personal data ordinance. So if you have a data breach, what will be the consequence? But at the same time, you will lose your company's reputations, and also you will subject to a lot of civil claim, potential civil claim. So all of this is so important for a company to rethink. Do you need to revise your handbook to lay down some guidelines or foundations for the employee to follow? So next slide, we talk about, as I mentioned, it is just the AML ordinance just concentrate to regulate the FI or DNFBP. So who are they? You will see FI, the financial institutions, that just refers to some organization, institutions, very, I think it is very understandable because it is some bankers, authorized institutions under the banking ordinance, or licensed corporations under security SFC, SFO, and some authorized insurers appointed insurance industry, and some licensed money service operators, the Postmaster General, or some store value facilities licensing, a licensed value add service provider. And if you are one of the members in this financial institutions, then you have to bear in mind you have some new duties to comply with. And next slide, we will also show you who are the DNFPB. You see, any kinds of the accounting professional, estate agent, legal professional, or TSP licensee, or Category B precious metal and stones registrant. It is, if you are in either way, you're caught by the ordinance, you have to. The next slide will show you. Under section 23 of the ordinance, all the FI or DNFBP have to ensure the proper safeguards exist to prevent a contravention of any requirement under Part 2, 3 of the set schedule to what is the requirement. It's very simple. By one sentence, it is already runs through several pages in the ordinance, but actually the main aim is try to identify the customers, your customers, and verify the customer's identity on the basis of the documents, data, information provided by the governmental body or other recognized bodies, which means when you are trying to assess or try to identify to your client's identity, you just cannot rely on other sorts of information, but the governmental bodies' information or recognized bodies' information. For example, Hong Kong ID card, passport, all this is acceptable. But other than that, it is still, because the ordinance still new, maybe you when the dispute bursts out, the different applicants will submit other documents just provided by the government, just like the immigration department, 行街紙, would it be possible? And yes, you will consider that sort of the negotiation will go on. And how about the when you breach this sort of thing, the anti-money laundering ordinance, what will be the consequence? And what should you do when you get your client's information? You have to keep it for at least 5 years. Section 20 of the AML will tell you is to keep the records for 5 years of your customer's risk assessment. And if you cannot comply with the ordinance, what could you do? What would be the consequences? It is a criminal offense. FI or DNFBP, the company, if they are knowing or with the intent to defraud the Hong Kong MA, they will contravene to specific provisions as listed in the Section 5, or if a person who is employee of the FI or DNFBP, or is employed to work for the company, or is connected in the management of the company, and knowingly or with the intent to defraud the company and HMA, that will be a criminal offense. And the possible punishment will be, as the next slide we'll see, if it just a breach of the specific provisions, the maximum penalty is the imprisonment of 2 years and a fine of 1 million Hong Kong dollar. And if you are intent to defraud, it is similar to the deception case, and the maximum penalty can be imprisonment of 7 years and fine of 1 million. But not just the company will be liable. Any persons as employee of the company or employed to work and connected in the management of the company and knowingly contravened to the specific provisions, or other the penalty is more or less the same as the company. You see. And that you will say, I just work for the company. How can we protect ourselves? Yes, of course, the judiciary will think about the balance of the interest under Section 7 of the AML Ordinance. It provides a statutory defense to the person. If the person to prove that he or she acted in accordance with the policy and procedure established and maintained by the company, the purpose of ensuring the compliance with the relevant specific provisions, then it will be a valid statutory defense. So you will see, for the person acting for the company, they can just use this excuse, you can say so, they'll act in accordance with the company's policy and procedure to shift the burden. But for the company, you have nowhere to hide, because you are the last resort to be responsible under this ordinance. Apart from the criminal offense, it is also the HKMA can impose the disciplinary actions and procedures against the company. They can publicly reprimanding the company, or also order the company to take any actions for the purpose of remedy the contraventions, or order the company to pay a pecuniary penalty, but not exceeding 10 million or 3 times of the amount of profit gained or the cost avoided by the company. You ask what's the cost avoid? It is if they think some things you have to do and some costs you have to invest in your business to avoid all these breaches, and you just ignore it, then the cost avoided or the cost you should invest in your business to comply with the ordinance, that's the penalty, that 3 times of that cost avoided. And next slide we will show you will tell that some of the AML or Employment Handbook will list out the applicable customer due diligence measures. I think you maybe you will consider trying to identify the customer and verify the customer identity. So you can also consider just put all these details in your office handbook. How to identify the employee who is responsible for the AML compliances, or some guidelines, or what to do in case if a suspected money laundering incident happen, what the employee should do, report to whom, or what is the necessary procedures for freezing or some seizing the assets from the suspected person. All these things, I think, should be well planned in advance, instead of just let it go, let it happen, and pay a very substantial lump sum for the penalties and also loss of your company's reputation. And also another hot issue is the remote work or mobile device. Is because the COVID, in the last few years, affect the normal business of the company. Some of the company would think about remote work is a very cost-effective ways to do the business. But of course, just like night both ends, you get the benefit, but at the same time, you consider that some disadvantage happened. Or just like when you have the remote work, how can you control the transmissions of the data from one terminal to another terminal to safe, and any leakage of your client's data? All these sort of things you have to consider and bear in mind to make some provisions in your office handbook. For example, nowadays some of the company will consider use the VPN or MDN to impose to their employees. They cannot just use their own personal computers or mobile phone to do the corporate business. Of course, it's quite difficult to make sure that all the employees will comply with, but at least you mark down in your office handbook. You lay down the procedures, you lay down the guidelines. If subsequently there's any leakage or there's some cyber threats happened in your company, then you can provide a very succinct defense to argue your case. And work from home security measures can be some mandatory use of the corporate device. Yes, it is highly recommended to separate your employees' personal mobile device or laptop from the company's computer, because if you calculate the loss from the sense of GDPR's penalties or personal data privacy or AML's punishment, you will think it is worth to invest. In some of the, especially you have to warn your employee not to try to avoid working in the public places or using some public Wi-Fi networks. If it is unavoidable, screen filters or the personal with hotspot should be used. Okay, and the some guidelines are how for the proper use of the storage of the company owned hardware, such as the computer or laptop. You can set up some password or biometric authentications or physical locks, or even encrypted the data stored in your device. It is a very effective way to protect your data. And some of the case studies, I just don't want to spend too much time, because when the case happened, and also you will get some lesson to learn. But in advance, you have to, when you think about to lay down the proper procedures, you have to think in a comprehensive way, not just because of something happened, so you pay attention to particular items. And next slide we'll see outlines the company's cybersecurity policy and procedure. You better to in your handbook lay down the guidelines for the password management or the data encryptions requirement and the access control. And it is another issues I want to just take out to discuss with all our audience, because the access controls seems to be very the costs involved should be minimal. But most of the victims of the cyber threats appears that they just even such a minimal cause that they don't just dare to pay attention. If you some of the every company have their hierarchy. Not every employee should access to very sensitive data of information of the companies. It's so reasonable. If you access control and access some access rights to control the your some juniors staff to access some sensitive information of your companies is such a reasonable procedures or to schemes to be implemented. I would say not just that sort of things. For IT purpose, you can have a different software. The slide 52, we suggest some of the database can be regulated. The security features, for example, some anti-malware software, virtual private network VPN, and some to secure the remote access. Some two-factor authentications feature reducing unsuccessful attempts to access data. All sort of this tools can you can consider to use in your daily cybersecurity scheme. Other prohibitions just like prohibit your staff on unauthorized reproductions of the employment-related data is also a very effective way to prevent the unnecessary or unfortunate leakage of the personal data. And some guidelines to deter unauthorized transmissions. You can prohibit the transmission, and also you can set out some security protection measures. For example, how to use sending or receiving emails containing personal data. All copies of the emails involving transmission of personal data should also be held securely to prevent accidental or unauthorized access. And you can use a different other areas you have to pay attention for the employees is the training, because even your guidelines laid down so dedicated and so careful, but if the employees, the attitude of the employees not cooperative, actually the whole scheme would not work. Guidelines to deter unauthorized transmission, that's all things we can do. And go to slide 54, please. Here you will see they provide the employee with some tips for identifying suspicious links. Yeah, training is important. Encourage them to report if there's a suspicious links or emails to the appropriate IT or security personnel. And also if there is some conduct, some regular trainings to remind your staff what sort of things they have to update, what is the reinforce the importance of the clicking on suspicious links, and also keep employee up to date on the latest threat and techniques used by the cyber criminals. It's also very effective to cut short the possibility of the data leakage. But of course, you will just synchronize with the echo with what Michael said. If your staff would know what's the consequence or how serious it will be for the leakage of no matter it's the client's data or the employee's data, then you tell them clearly in your guidebook. Say for in the slide 55, we will talk about you can they will subject to disciplinary actions, terminations of employment, or the legal consequence. Just tell them how serious of the consequence will be. It will be also another effective way for helping your staff to comply with your cybersecurity scheme. So here is all I want to share with all of you. Next stage is next topics we'll try to talk is the controversial issues, especially the Discrimination Ordinance. I pass the time to Michael.
Michael back. Now we are going to talk about some issues about the Discrimination Ordinance. And why this is an important topic to talk about is that we mentioned a lot about what should be put in the employment handbooks, but there are things that we should avoid putting in the employment handbook. And also, if there is some harassment or discrimination scenarios happening within your company, putting some provisions in the employment handbook may help. Now, in Hong Kong, we only have 4 discrimination ordinances. The first is Sex Discrimination Ordinance. Second is Disability Discrimination Ordinance. For this one, we name it as the Disability Discrimination Ordinance, but it also deals with illness, sickness. The third one is Family Status Discrimination Ordinance. For example, if a pregnant lady is being discriminated, the situation may fall within the Sex Discrimination Ordinance or Family Status Discrimination Ordinance, depending on the circumstances, of course. And the last one, which is the relatively new one, is Race Discrimination Ordinance. Now, in the event of a successful prosecution under anti-discrimination ordinances, there is no limit to the amount of damages a court may award. So, as an employer, you must be very aware of these situations that may lead you into financial troubles. And these compensatory damages may be assessed according to the loss of earnings and injury to feelings caused by the act of discrimination. In particular, damages for injury or to feelings can be quite substantial. The range is very wide, but there are cases awards for injury to feelings range from $100,000 to $150,000 for each of the 3 plaintiffs, with each plaintiff receiving an average of $800,000 on average, in overall damages, I mean. So how does that relate to the Employment Handbook? Well, first, you have to think about how to provide a channel of complaint, and you have to also consider any provisions that may cause discrimination and must be avoided. So these are, this can be a separate talk on these topics because discrimination itself is a very big topic and of course employment related. And if we have a chance, we can dive in deeper with you to see how you may tackle these discrimination issues. Our presentation today comes to an end, and next will be the Q&A section. We'll see if there are any questions coming in, and hopefully we can try to answer your questions.
Hi, Michael. Thank you very much to yourself and Millie for your wonderful presentation. Unfortunately, we are 15 minutes over our allotted time today. Any questions that we haven't had time for will be sent on to the panel. What I will ask before we finish, if there are any key takeaways from yourself that you would like our audience to leave today's webinar with, that would be really appreciated to hear from you on that. Thank you.
Key takeaway. First of all, Employment Handbook is very important. Like it may not be a legally binding contract, but you have to think about what to be put in the employment contract and what should be put in the Employment Handbook. The status of an Employment Handbook is more like a guidebook, so you really have to think about whether some terms should remain a guidance or actually a contractual term. And the employment handbook terms have impact on a lot of different aspects of employment. We focused on data security, focused on personal data protection, and we briefly mentioned discrimination. So these are matters that you have to think about putting into the employment handbook to provide your employees a good guidance on how to deal with the matters that I just mentioned. And also you have to think about what not to be put in the employment handbook to protect your own company or to avoid any claims of discrimination. So these matters is very wide, and we encourage you to seek professional help when you design your employment contract or employment handbook.
Brilliant.
Yes, indeed. I completely, of course, agree with what Michael said. Especially so when you think about your office handbook, it is not just a handbook to provide some general guidelines to the employees. You just provide some answer or solutions for the employees when they are just coming across some difficult time, when they just when the email account have been hacked by some persons, or there's some data leakage, what they should do. It is not just good for the employee and also good for the employer as well. Because I've already explained, if you have some data leakage or data breach, company is the last resort to pay for the damages, to be responsible for the penalties. And if you just don't reconsider whether your current office handbook is sufficient to cover all these recommendations or not, it would be if you eventually unfortunately become the victims of the cybercrime, then you cannot provide any reasonable defense to the court. And also to the EU, that's what I want to point out. For the EU, we also cannot subject to our certain negotiations, telling that we are trying our best to do what we can do, but if it's unlucky, the hackers just come in and do some things that we cannot avoid. I have a deep talk with some of the IT experts in Hong Kong. They also share with me have some consensus that more than 80% of the cybercrime is not because of the imperfect IT system. It's just because of the human negligence. The human negligence can only be removed by proper training, just enhance their awareness, and also some better office handbook procedures or policies of the company should be implemented. So all the things, although you will think in your mind, office handbook is such a simple document, but in my positions, I would highly recommend you just review your office handbook to see any things that you can do better.
Brilliant. Thank you very much for that, Millie, and thank you, Michael, as well for your time today. A very in-depth look at a very important topic, so thank you for that. And to our audience, thank you for being with us. You can see Millie and Michael's contact information. Please do get in touch if you require any further information. And you'll also see a CPD application form attached here, which we'll be circulating with you after the webinar as well. So thank you very much again for your time today. Hope you have a lovely rest of your day, and we will see you again soon. Goodbye.
Goodbye.